Good afternoon, everybody. Welcome to the first Monday in October in a brand new Supreme Court term. I'm Associate Dean of Research and Intellectual Life, Kristin Hickman, and I want to not only welcome you here, but also say how delighted I am to have three of my wonderful colleagues, Professor Nick Bednar, Professor June Carbone, and Professor Sam Merchant with me today to talk about some of the cases that the Supreme Court will be considering this term. Obviously, with only an hour to chat, we can't cover everything, but we've tried to come up with a collection of, sort of a wide variety of different cases hitting on different topics that provide a little bit of something for everyone. So I am the boring person here. I am just the moderator. So with that, I'm going to start turning it over to my colleagues. I don't have a clicker. Maybe they can change the slides. Starting with Professor Nick Bednar. But first, where is a clicker?
Okay, so if not, I'll just project. All right, so I'm going to discuss presidential power at the Supreme Court, and in doing so, my presentation will reflect the chaos of the moment. So when Professor Hickman approached me about presenting today, we both agreed that there needed to be some coverage of presidential power and review of executive orders at the Supreme Court. But at the time when we prepared this presentation behind us, there actually had not been cert granted in any case involving presidential power. But if you've been following the news, you might be thinking, well, that's strange because I've been seeing the Supreme Court do a lot of different things with respect to all of the Trump administration's executive orders. And so you might be thinking, well, Professor Bednar just doesn't understand what he's talking about, which is sometimes true, but thankfully not the case today. So the key to understanding presidential power at the Supreme Court, particularly over the last few months, and as we are likely to see in the next few months and during this term, is understanding the shadow docket. So most of the cases you read in law school or that you see in headlines are actually merits decisions. So these are opinions that the Supreme Court has issued after full briefing and oral argument and time to consider the opinions. But there's another faster track way that the Supreme Court chooses to decide particular issues, and that's the shadow docket. So the shadow docket includes emergency orders and summary decisions that the court issues without full briefing or an opportunity for oral argument. Sometimes these orders are issued late at night, and they often lack significant amounts of reasoning. They may include one or two paragraphs at most that explains why the Supreme Court is taking the decision that it's taking. So in recent years, the Supreme Court has relied on the shadow docket quite heavily and more visibly to shape major legal issues on immigration, voting rights, and presidential power. And critics worry that the shadow docket lacks transparency and accountability, but supporters argue that it's necessary for managing emergencies. So whatever your opinion of the shadow docket actually is, it has become a core vehicle by which the Supreme Court has sought to review many of the issues in presidential power and administrative action that have been emerging over the last 9 months. So the two cases on the screen are emblematic of how the Supreme Court has used the shadow docket. So subject to a few notable exceptions, a pattern has emerged of the Supreme Court granting requests by the Trump administration to stay district court orders. So often what we see is the Supreme Court is asked to consider things like whether the Supreme Court should stay the district court's injunction prohibiting the removal of members of the Merit Systems Protection Board and the National Labor Relations Board pending appeal. So the court is not actually saying in these cases, more often than not, what its decision on the merits is. It is just making a determination of whether to uphold the district court's order during the pendency of appeal while the case works its way through the lower courts. Now, this has caused confusion in many of the district courts as they've sought to manage the litany of cases challenging executive action. So you often get this order that has maybe a paragraph or two on what the Supreme Court's deciding, and the district courts don't necessarily know how to apply that to similar cases. And so there have been some Supreme Court justices who have criticized the district courts for not following Supreme Court precedent based on these short decisions, but a lot of times there's little guidance for how the district court should be applying these cases. So I'm going to skip my discussion of Office of Personnel Management v. Trump and focus on Wilcox v. Trump because of some things that have developed since we initially put together this slideshow. So one of the longest standing questions in constitutional law is, does the president have authority to remove subordinates within the executive branch? So although the Constitution is silent on the issue of removal, proponents of unitary executive theory argue that Article 2 vests the executive power in the president, and therefore the president needs sufficient tools to control subordinates or anyone exercising executive power. And many conclude that the need for the president to remove principal officers is just incidental to his power to appoint these officers who exercise executive power. So one of the earliest cases to address this is Myers v. United States, in which Chief Justice Taft took a very broad understanding of this removal powers, concluding that the president has unilateral authority to remove purely executive officers without Senate consent. But 9 years later, the Supreme Court jettisoned much of Taft's reasoning in a case called Humphrey's Executor. So Humphrey's Executor concerned a statutory provision of the Federal Trade Act that stated that members of the Federal Trade Commission could only be removed for inefficiency, maladministration, or neglect. And President Franklin Roosevelt removed then FTC Commissioner William Humphrey for policy reasons. Now, the Supreme Court ultimately concluded that the removal protections for the FTC commissioners were constitutional and upheld it on grounds that the FTC is a multi-member institution that exercises quasi-judicial and quasi-legislative authority. So for a long time, Humphrey's Executor stood for kind of the principle that Congress could, at least in some instances, restrain the ability of the president to remove officers. And the Roberts Court has chipped away at Humphrey's Executor in a series of cases, the most notable of which I think is Saylor Law. So in Saylor Law v. Consumer Financial Protection Bureau, the court considered whether Congress could constitutionally limit the removal of a single director of a federal agency, in this case, the Consumer Financial Protection Bureau. And the Supreme Court concluded that vesting executive power in an officer who was not removable at will by the president violated Article 2. Yet Chief Justice Roberts reaffirmed Humphrey's Executor as good law, but something narrowed the traditional interpretation of Humphrey's Executor. So according to Chief Justice Roberts, Humphrey's Executor applies only for multi-member bipartisan commissions that exercise quasi-judicial or quasi-legislative functions. So that brings us to January 2025, when President Trump sought to remove Gwen Wilcox from the National Labor Relations Board and Kathy Harris from the Merit Systems Protection Board. So both the National Labor Relations Board and the Merit Systems Protection Board are similar to the Federal Trade Commission in that they exercise quasi-adjudicatory powers, and they, the commissioners or members of those boards enjoy for-cause removal protections. And so you might think that Humphrey's Executor would apply to these agencies. And in the U.S. District Court for the District of Columbia, Judge Beryl Howell ruled for Wilcox and Harris, but Harris was in a different case at the time, concluding that Trump's removal violated the statutory provision limiting removal of NLRB members, and that the removal protections were constitutional under both Humphrey's executor and SALA law. So the DC Circuit refused to stay Judge Howell's decision and ordered reinstatement of Wilcox pending appeal. The Supreme Court considered the government's application for a stay of the lower court orders, and in a 6-3 per curiam order, granted the stay. Now, the majority justified the stay on the removals, or on the district court's order, by saying that the president was likely to show that the MSPB and the NLRB exercised significant executive authority. But it did not decide whether Humphrey's executor applied to these two agencies. Nevertheless, the Supreme Court included a bunch of language in it talking about the Federal Reserve and how its removal protections were different. Now, this is somewhat strange because at the time of this order, President Trump had not removed any Federal Reserve commissioners. That has changed as of today, or not as of today, but as of recently. And the Federal Reserve was not before the court in any capacity. So many commenters interpreted the Supreme Court's order in Trump v. Wilcox as the first sign that we'd probably see Humphrey's executor overturned in this upcoming term. And 2 weeks ago, the Supreme Court granted cert in a case called Trump v. Slaughter, which concerned the removal of an FTC commissioner. So President Trump removed 2 members of the Federal Trade Commission. Recall from what I just said a moment ago that the Federal Trade Commission is in fact the agency that was before the Supreme Court in Humphrey's executor. And so this was a pretty clear violation of existing Supreme Court precedent, or about as close of a violation as you could get. And so the Supreme Court will consider in oral arguments in December whether to uphold Humphrey's executor. Now, there are 2 possible ways this case could come out. There's like an infinite continuum of possibilities, but 2 I think that are more likely than not. So the narrowest approach would be to say the Federal Trade Commission is different than the Federal Trade Commission that existed in the 1930s. So Congress has expanded the powers of the Federal Trade Commission in several notable acts. The DC Circuit has also interpreted the Federal Trade Act in ways that expanded the Federal Trade Commission's authority. And so perhaps the Supreme Court will say, Humphreys remains good law, but this FTC is different. Now, that would raise a bunch of questions about under what conditions Humphrey's executor is actually good law in which the rule applies. The broader approach the court could take is it could just overturn Humphrey's executor in saying that any officer who exercises significant executive authority is subject to presidential removal. Now, it would have to carve out an exception, probably based on its dicta from Trump v. Wilcox, for the Federal Reserve, and we'd have to see what that looks like. But it would be a stark departure from what the court has said in even recent terms regarding the permissibility of these sorts of protections. So what we're likely to see in this term with respect to presidential power is both an expansion of presidential power in these merits decisions that are considering the removal power, but also a greater number of shadow docket cases where the court is asked to take up issues related to executive orders, and we'll just have to see what the court says and if it grants certiorari in any of those other cases.
Thank you so much, Professor Bednar. Turning then, I don't know if this works. I need somebody else. Thank you. Turning then to Professor Carbone, who's going to talk about a pair of cases dealing with LGBTQ rights.
All right, so let me set the context for these cases. If you were to go back, say, to before Obergefell, the Supreme Court decision that granted a constitutional right to marriage equality, the underlying constitutional right to equal protection and most statutes guaranteeing protecting against discrimination on the basis of sex had not been interpreted to provide protection on the basis of either sexual orientation or trans status. And the really interesting case that changed that in a decisive way was Bostock. This is a Title VII case addressing employment discrimination. There was a great deal of speculation that the court would refuse to find either group protected under Title VII. But in fact, in an opinion authored by Justice Gorsuch, the Supreme Court held that discrimination on the basis of either sexual orientation or trans status was in fact sex discrimination within the meaning of Title VII. The court argued, what is discrimination on the basis of sexual orientation other than discrimination on the basis of the choice of one's partner? And since if you choose a partner of a different sex, that's fine. If you choose a partner of the same sex, that is the subject for adverse employment action in the cases before it. That is discrimination on the basis of sex. The same thing with transgendered status. If the employer says somebody assigned the sex of female at birth can wear a dress to work, but somebody assigned the gender of male at birth cannot, that is discrimination on the basis of sex assigned at birth, and it is sex discrimination within the meaning of Title VII. So since then, the appellate courts have applied that principle to a number of other statutes and provisions. That then sets up the question, what about this wave of restrictive legislation addressing transgender issues that has arisen recently? So the most important recent Supreme Court case in the last term was Skermeti. In the interest of full disclosure, I joined an amicus brief on that case. And that was a case where Tennessee had prohibited various kinds of gender affirming care below the age of majority. And there was, we thought, a fairly clear sex discrimination argument that went something like this. If you have somebody who is assigned, let's say they're assigned male at birth, and they have, some kind of issue, such as low testosterone levels, and the ordinary medical treatment would be some kind of hormone treatment, fine, no problem. If instead they are assigned gender female at birth and want access to the exact same therapy in order to transition to a gender more compatible with their self-identity, that is forbidden by the statute. And so the argument is, was this sex discrimination within the meaning of the Equal Protection Clause, which applies intermediate scrutiny to sex discrimination cases? And the Supreme Court held in Skermeti that this was not sex discrimination. Instead, it was a distinction based on age. People above the age of majority had access to these treatments, but not below the age of majority. And it was not discrimination on the basis of sex. Instead, it was discrimination, or a distinction rather, on the basis of the diagnosis. If you had one kind of diagnosis, let's say your sex assigned at birth was male, and you were developing in a way that was not gender typical, and you wanted certain treatments so your development would be gender typical, you had access to these treatments. If you had a different diagnosis, then, namely gender dysphoria, then you could not receive these treatments. Therefore, the court held this is not discrimination on the basis of sex. And the court said, since it is not discrimination on the basis of sex, it does not trigger heightened scrutiny. And the legislation passed muster on a rational relationship test. There may be side effects from this treatment. The legislature can make a judgment about those side effects. And let me note that the court granted cert on that case only on the equal protection question, not on issues of parental rights or due process or access to medical treatment or any of those other issues. It bracketed those issues solely on equal protection grounds. So the two cases that are pending this term deal with the question of transgender participation in sports. And so let me take the first, which comes from Idaho. And Idaho passed a law in 2020 categorically banning women and girls who are transgender from participating in all women and girls sports teams from primary school through college at every level of competition, from intramural to elite teams. And the Ninth Circuit affirmed the district court's preliminary injunction, concluding that this was likely a violation of the Equal Protection Clause. The plaintiff in the case, a transgender woman, had participated at the University of Idaho in the women's club running and club soccer teams. So she was on the women's teams at the club level. She tried out for the university level teams and didn't make it. She wasn't fast enough. So in this case, as I said, the Ninth Circuit had ruled in her favor that this is sex discrimination, and the Supreme Court has granted cert. I would note that one of the really awful things about this particular statute is it doesn't just bar transgender athletes from competing as women. It doesn't apply to men, to transgender men who want to compete on men's teams, but it also allows any other person involved in competition to challenge the sex of a person competing as a woman that would then subject the athlete to a determination, including intrusive physical exams and other kinds of investigations to determine eligibility. And the conclusion of the lower court had been not just that this violates equal protection, but that it also didn't advance any legitimate stated state interest, because there really had been no issues in Idaho about competition among transgender athletes or findings that it interfered with the ability of those assigned the gender female at birth to compete. But the question before the court is whether laws that seek to protect women's and girls' sports by limiting participation to women and girls based on sex violates the Equal Protection Clause of the 14th Amendment. The second case arises from West Virginia. And the West Virginia, and this case is slightly different in a couple of respects. First, the case is brought under Title IX as well as under the Equal Protection Clause. And so it involves both the statutory definition of what sex discrimination is, as well as the constitutional provision. In addition, the West Virginia law applies. The plaintiff in this case is a 13-year-old transgender girl who had taken puberty blocking medication and is publicly identified as a girl from the 3rd grade on, and involves participation in middle school sports. So it is at a different level, and with somebody where the taking of the medications almost certainly eliminates most of the claims of advantage. And this is non-elite competition. So it is a particularly sweeping ban. And the U.S. Court of Appeals for the Fourth Circuit ruled that West Virginia's ban violates Title IX, the federal law that prohibits discrimination in educational programs and activities that receive federal funding, and also found that it didn't meet the intermediate scrutiny test. So the court, in approaching these cases, could simply say that first of all, they could say this is not sex discrimination. What the court has been doing in a number of these cases is reviving an older set of doctrines that say, hey, if women are different from men for biological reasons, that's not sex discrimination. So the infamous case doing this some decades ago involved pregnancy discrimination. The Supreme Court said there are two categories. There are pregnant women, then there are non-pregnant women and men. Something that discriminates against pregnant women is not sex discrimination because the category pregnant is not coextensive with the category women. And the court revived that reasoning in Dobbs, saying that a negative effect on pregnant women is not discrimination on the basis of sex that applies to women. And it did it in Schermetti as well, again, as I mentioned, saying this is not sex discrimination, it is a distinction based on pregnant status. I mean, not pregnant status, on diagnosis and age. So the court might well say the ability to participate in on female teams. First of all, the court has held legitimate that nobody really questions that you can have teams divided in terms of men and women without that constituting sex discrimination. Then you get into the question of how one determines who is eligible to compete. If you say somebody who is assigned female at birth is the only person who can compete on a women's team, is that sex discrimination? The court could simply say no. And that simply says the states can do whatever they want. The court could reach, and Justice Kennedy, in his opinions on sexual orientation, didn't necessarily rely on heightened scrutiny, but rather on the existence of a legitimate state interest for distinguishing between same-sex and different-sex couples. For example, in Obergefell, I think the question of the mechanism that allows anybody at any time to question whether or not somebody who identifies as female is female and on what basis, with sex assigned at birth as the only basis for the determination, the court could try to address that issue separately. But that's really a due process rather than an equal protection issue. So whether the court will or not, I don't know. And the court could say that either of these statutes are simply too sweeping because they don't turn on any kind of findings that depend on whether the particular athlete has an advantage or not. This applies to all sports where there are women's teams and to all athletes who have a sex assigned at male at birth are prohibited from competing. So these are particularly sweeping laws, and the court could uphold them as simply not involving sex discrimination at all, or the court could distinguish the different aspects of the different statutes.
Thanks so much. If we could advance the slide one more time. Other direction. There we go. So now I'm going to turn it over to Professor Merchant.
All right, so I have the case in Rutherford and also combined with another case, but I'll try to be brief so we can save some time for questions. I'll start out by maybe a thought experiment. Imagine that you are a bank robber. You're kind of down on your luck, and you're a bank robber, and you decide to rob a couple of banks in the 2000s, and of course you get caught, as most bank robbers do. These are federal offenses, and at the time, a harsh, tough-on-crime law that was in force required that for each of these offenses, your sentences must be stacked. So for most federal offenses, judges can combine these sentences together. The sentences are pretty harsh anyway, and so they get combined and you serve combined sentence for all of your offenses. But for these types of offenses, especially where guns are involved, the tough-on-crime law from the 80s required that these sentences be stacked, and so you would serve 25 years plus 25 years plus 25 years for these bank robberies. This led to absurdly long sentences of hundreds of years sometimes, based on stacking of these different offenses. This is 18 U.S.C. 924C. And judges even at the time, while they're sentencing individuals for these offenses, were acknowledging, I know that this sentence is absurd, especially when I consider other offenses. So the relative severity of this offense compared to other offenses, I know that this sentence is absurd, but my hands are tied by Congress and I have to stack these sentences. And so you get a sentence of 150 years when a murderer might get a sentence of 30 years, and so everyone knew at the time that these were absurd. Even Congress knew after a few years of these sentences being imposed that they were absurd. And Congress ultimately repealed this law a few years ago in the First Step Act. So a person sitting next to you now decides to rob a bank after these reforms would get sentenced consistent with other areas of federal sentencing and would get a normal sentence of 10 or 15, maybe 20 years, depending on the facts and aggravating circumstances of the offense. The question then is, what happens to you, right? So you were sentenced in the 2000s under these laws from the tough on crime laws from the 80s. And you're still serving this long sentence, but someone sentenced today for the exact same offenses would get a substantially shorter sentence. What happens to you? Congress answered that question in the law, so in the reform. And Congress said that these reforms are not retroactive. And so individuals who commit these types of offenses that are sentenced under this law do not face these sort of stacking offenses after the effective date of the statute. But individuals who are sentenced before the effective date, their sentences remain unchanged. So Congress said that in the law. And if that were the end of the case, this would not be at the Supreme Court. So there must be something else going on here that brings it to the Supreme Court. The real issue in Rutherford concerns an agency within the judicial branch, so the United States Sentencing Commission. So that's what's at issue in Rutherford. Congress created the Sentencing Commission in the 1980s at the same time that it enacted these sort of tough on crime laws. And importantly, Congress also abolished the United States Parole Commission at the same time. So before this point in the 1980s, you had the Parole Commission. A judge would sentence you to, say, 20 or 30 years. The Parole Commission would decide how long you actually serve. And so if you've been rehabilitated, you're ready to be released after 5 years, you might get released. After 10 years, you might get released, right? But the Parole Commission ultimately made that decision. That system was completely eliminated in these tough on crime 1980s reforms. And Congress created the U.S. Sentencing Commission as a result. At the same time, it eliminated the Parole Commission. It enacted truth in sentencing laws that required that you have to serve at least 85% of your sentence in the federal system. This is why the federal system is seen as so much harsher than state systems, is because you're required in almost every circumstance to serve at least 85% of your sentence. So we get rid of the Parole Commission, we add new mandatory minimums, we add these tough stacking laws in 924C, and you have the Sentencing Commission created as well. But Congress at the time also created a tiny safety valve in the 1980s. And this is the so-called compassionate release statute. So Congress creates this tiny safety valve, and it said in certain very narrow circumstances, if you check about 10 different boxes, and in quote, extraordinary and compelling, if there are extraordinary and compelling reasons to reduce your sentence, then a judge can reduce your sentence in these narrow circumstances, right? So the tiny safety valve was created, and as the lawyers know, and you future lawyers know, we define every term, and then we define the words that are in the definition, right? And so we need to define what it means to be extraordinary and compelling reason for a sentencing reduction. Here, Congress did not give a definition of what an extraordinary and compelling reason actually was. And it said, we are going to leave that for the newly created U.S. Sentencing Commission to decide what a quote extraordinary and compelling reason is for a sentencing reduction for a sentence after the fact, right? And that's where Rutherford's case comes in. So if you recall, he's serving this extraordinarily long sentence based on this tough on crime 1980 stacking law, which Congress amended a few years ago and repealed, and the Congress said was not that change was not retroactive. So he's still serving what might be considered like a stale sentence. But here the issue in Rutherford, if we sort of phrase the issue in a way that I think makes sense, can a non-retroactive change in law that new offenders benefit from and older ones don't qualify as an extraordinary and compelling reason to reduce someone's sentence under a completely separate statute? That's the real issue in Rutherford. So at this point, it's an issue of statutory interpretation. We have these two different statutes. They're sort of statutes that are competing. But there's another issue. If you'll recall that Congress said that it's the U.S. Sentencing Commission that gets to define what it means to be extraordinary and compelling, right? And last year, the U.S. Sentencing Commission amended the federal sentencing guidelines to say that non-retroactive changes in law can be considered as a factor among many as an extraordinary and compelling reason for a sentence reduction. So that's another issue in the Rutherford case. So you don't get to benefit, the offender doesn't get to benefit directly from this statutory reform. They might benefit in a different statute if that reform is considered extraordinary and compelling. If you're serving this long sentence and Congress says, okay, we think this is a long sentence and we're going to change the law, do you get to benefit by that through this other statute, even though you don't get to benefit through the direct statutory reform? This seems intuitive that, Congress says, okay, we admit that these sentences are too harsh, we're going to change this. People who are sentenced under the existing regime might benefit from that. We can sort of debate that, but it seems intuitive. And there are just a lot of questions that this case raises. First of all, can Congress actually delegate this authority to the U.S. Sentencing Commission? Did it delegate this authority to the U.S. Sentencing Commission? But really what is working behind the scenes in this case, and you won't see this in much of the briefing, a couple of the amicus briefs talk about this, but the merits briefing doesn't talk about this. You probably won't hear this at oral argument. But what's really going on in this case is a debate about second look sentencing, quote unquote second look sentencing, right? And so second look sentencing, you can think of an individual sentenced in 1991, for example, some draconian sentence of 200 years, right? Because it's this tough on crime era. Is there a mechanism in our system, and should there be a mechanism in our system to revisit that system as society sort of changes and we realize, okay, maybe we went a little bit harsh on this sentence, right? Some people propose that, every 10 years, every 20 years, whatever it is, we revisit these sentences and make sure that they still align with society's norms and what we think of as justice. So should there be a mechanism in federal sentencing that allows for that, a second look at these sentences? Right now, there's not. This is the only one that exists. I mean, there are a couple of other ones, but they're even harder than this one, right? And so proponents of second look sentencing don't want to close this opportunity, don't want to close this mechanism for at least a narrow ground to revisit some of these harsh sentences. And then individuals who are opposed to second look sentencing obviously don't want this to be some sort of clever lawyer loophole to open the door to second look sentencing unless Congress expressly intended for that to happen. And so that'll be the debate in Rutherford. I think that covers Rutherford and Carter. Happy to take any questions on those questions, and I think I can turn it back over to Kristin.
Okay, well, I have questions, but it's more important to me that you all have a chance to ask questions. So we have a couple of microphones over here. What I'm going to propose is that I kick things off with a question, but invite audience members to line up at the microphones, and I'll turn to the microphones as soon as my question gets answered, unless no one is lined up. But please, stand up. Don't be shy. Come ask questions. Anyway, okay, so I'm going to start with a question for Professor Merchant here, which, of course, because this is a statutory interpretation question, and many of you know I'm a statutory interpretation geek, I guess one question that I have is whether you think that in giving the Sentencing Commission some discretion to define what constitutes an ordinary or compelling reason, does the Sentencing Commission have sufficient discretion? Is it included within that delegation to include non-retroactivity within the scope of extraordinary and compelling reasons? And if not, why not?
Yeah, so I think as a matter on the statutory interpretation front, I think what at least a majority of the justices will probably say, knowing that predictions are difficult, especially about the future, that caveat. But what a majority of the justices will probably say is that Congress was quite clear in the First Step Act that non-retroactive changes won't be considered, right? And the statute's not retroactive, and so non-retroactive changes in this other statute isn't going to be a loophole to that otherwise absolute rule. I think what the court, if they get into the issue of delegation and the U.S. Sentencing Commission, I don't think they need to get into that. First of all, I think they can resolve this on statutory interpretation grounds. But if they get into that at all, I think that they will say that Congress told you to consider these extraordinary compelling reasons for things that Congress hadn't already thought of, right? So if there's something that Congress was silent about, then you can start enumerating extraordinary and compelling reasons. But if Congress says something's not retroactive, then Congress did think about it. And so that's not something you could consider as extraordinary and compelling. So I think there'll be some justices that disagree with that, but that'll probably get a majority of the justices on board.
Great. Let's start over here.
Hi, this is on, is not on.
I'm not sure.
Okay, I'll project. This one is for Professor Carbone, and it's in the LGBTQ arena. So the Supreme Court is about to hear the Colorado conversion therapy case, which the Colorado statute bases on kind of a medical diagnosis. And so I was just wondering on your take of whether Scrimeti could actually be kind of a shield for Colorado because it's a state making a medical determination, or do we think like this court is, hell-bent on rolling things back and that's not going to stand in their way?
Yeah, and if I'm not as up on that as I am on these cases, but my recollection is that it's a First Amendment issue, whether it violates the religious preferences of the therapist to be able to, or the patient, to be able to provide conversion therapy consistent with the religious beliefs or one or both. And I don't want to predict how the court, I can't predict how some justices will rule on anything involving religious preferences. Whether there are 5 votes to say what is really a medical determination on the both legitimacy of the therapy and the potential negative side effects, whether you can have religion override that, I defer to those people who are experts on the First Amendment. Sorry, I don't know if anybody else knows more about that than I do.
No, but although I will point out, whenever I teach constitutional law, I tell my students all the time, there are many different ways to frame questions. Actually, this is true in probably any area. And so much depends upon the framing of the question, which amendment we're talking about or which provision of the Constitution. Anyway, okay.
Can I say one more thing about that? I think the framing is the issue. And, you have a whole set of cases about what information providers can be compelled to provide. So there's a California case where you have, I forget what they're called. They're abortion centers, but the state of California wanted to compel the abortion centers that are designed to persuade women not to have abortions, to tell the women that the state provides abortions, with state subsidization. And that was ruled to violate the abortion center's First Amendment rights. So there's been a particularly expansive reading, and if it's viewed as a First Amendment issue as opposed to an issue about medical care, that could determine the outcome.
Next, please.
Well, first of all, thank you so much for your time. I'm curious on a general note, how we as students can be equipped both as peers, but also with those outside the law school to have conversations about the current activity in the court in ways that takes into historical context and encourages trust in our institutions, and not in a way that perhaps casts a dubious shadow over the future of America. You mentioned the New Deal, and so we've obviously come through great ordeals between the executive and the court. How do we understand our present moment with those questions in mind?
Okay. I can take this. So, I think there are a couple answers here. One of which is you should all read widely. So, in every legal dispute, right, there are 2 sides, which means there are generally 2 attorneys arguing good faith arguments about why they believe the law means what it means. So, part of the answer, right, is you should seek to understand both sides of any argument. Now, right now, because of how the Supreme Court interprets the law, that probably requires some amount of historical knowledge when we're talking particularly about presidential power, maybe not with respect to other arguments. The Supreme Court has taken a rather originalist view of how we should interpret Article 2 of the Constitution. And so that means if you want to engage in arguments related to Article 2, you need to understand kind of what is answered by those historical documents and what's not. So I think that's, one answer is just you should read widely and you should try, even if you disagree with an argument, to understand what the position is. Now, that doesn't always mean, right, that the other position is asserted in good faith, but you should try to figure out whether it is and what the standing of the argument is. Two, I think to some degree as lawyers, you have to have faith in the fact that the rule of law holds. If you don't have faith in the rule of law, there's no real reason to be an attorney, right? If you think everything can just be arbitrarily decided by judges based on political beliefs or that the president is permitted to ignore the law, then why are you here? So, you have to have some kernel of faith that it is possible to preserve the rule of law and, keep that in mind.
Yeah. I have a slightly different take on this, but it's very hard to avoid cynicism at this point in our history, and the shadow docket has encouraged that because of the lack of an explanation. So you're left guessing. And when that happens, it's easy to attribute ill motive when you disagree with things. But I find one of the most disturbing developments is the criticism of justices after issuing opinions. And I will give you an example. In the ACA case, in which Justice Roberts provided the fifth vote upholding the ACA, but simultaneously upheld the ACA with respect to the individual mandate, and found that the states could not be compelled to accept Medicaid expansion. So I was following that very closely, and I thought, and I have taught that case, comparing it to Marbury versus Madison, and a justice locking in the legitimacy of the court by essentially doing things that weren't predicted based on where the judge was starting from. When I looked at the polls following that case, following the ACA decision, the Supreme Court's polling was at something of an all-time low, and it was conservatives who had shifted in a much more negative direction. And when I am watching the current justices, one of the things that I have been very disturbed by is, for example, with respect to Justice Amy Coney Barrett, the criticism, if she is seen as in the center, issuing more nuanced opinions that go totally toward one side or the other, I see her getting incredibly vicious criticism from both sides and find that appalling. And I think that the negative reaction that takes the form of death threats, of dismissal of the individual justices, maybe making fun of them is appropriate in some cases, but I don't object to humor. But the disparaging comments that occur simply because of disapproval with the outcome of the cases, I find pretty appalling. And I think it breeds the polarization, not just in the larger society, but on the courts. The only people who say nice things to you are people who are on your side politically. I think that's an incredibly negative development on the part of the courts. And you see it with justices who only speak to groups with whom they're politically aligned because the hostility from other groups is too overwhelming. That, I think, is a disturbing development.
Just a couple of things to add. I mean, I have become sort of, and this is in the context of the Supreme Court and elsewhere, but I've been sort of fascinated by decision theory and what really goes into decision making. And it's an interesting endeavor at the Supreme Court to try to figure out sort of what goes into their decision making. I think at a certain reductionist level, a part of that is the justices saying this is a better way to run a country, right? And so they get to choose their theory of interpretation. Nothing obligates them to apply originalism or living constitutionalism or the other. They get to pick that theory of interpretation. I think at some level they're saying this leads to better outcomes for the country. This is a better way to run a country if judges are originalists or not or whatever it is, right? Well, why are they making that decision, right? So I'd like to probe those questions. And direct answer to the question, I think it's important personally to engage with, in good faith, history and tradition And understanding the American traditions, for me, it's not sort of for its own sake, but it's in furtherance of that first point that I just made. It helps you understand the decisions that the justices are making, and you can see whether their decisions are consistent with history and tradition or not. And if you understand the history and tradition, you can make that type of analysis. If you don't, if a decision is not consistent with American tradition, then you can start asking further questions. Why is this decision not consistent with our history and tradition? Like, what is it about this that's different? Set aside whether they're engaging with history and tradition in good faith, right? I think there's a difference between academics doing that, law students engaging in history and tradition, versus judges doing that, and justices on the Supreme Court. There's different uses of history and tradition. But I think to answer the question, it's important to really understand in good faith our history and our traditions, that you can understand why the justices are making the decisions they're making. And then lastly, I'll say it's important, especially important for lawyers in our current society. Non-lawyers are going to look to you for guidance about the law, and they're going to look to you for clarity, lucidity, the best arguments about the law, and sort of clear recitation of what this Supreme Court decision is or what this law is or whatever. And so it's just really important for me, for lawyers, to sort of resist the urge to sort of have emotions overwhelm you, or a political sort of belief overwhelm you, and really try to understand these issues in good faith, because the public's going to look to you for that. And I see that not happening a lot in our current system, where lawyers are sort of operating in bad faith.
Okay, I'm going to take this opportunity to add just one further thought, which is that I think law school contributes to breeding cynicism in a certain way, precisely because what do we do all the time? But we sit around and we critically analyze and point out the flaws of different court decisions. That's our job, to help you all learn to look at opinions and think about them critically and recognize their limitations in their analysis, or, raise questions about them. It wasn't until after I graduated from law school and clerked for a judge and had opportunities to interact with judges and really discovered that for all of their disagreements, and there were lots of disagreements, some of them very passionate, they were all trying to do their best to find the right answers to the cases in front of them. And that actually gave me a lot more faith, at least in the court system, than I had when I was in law school, because all you need is to see somebody who you recognize as being smart and hardworking and earnest, trying to do their best. And even if you disagree with them, it bleeds away a little bit of that cynicism about, people acting in bad faith or reaching decisions because of motives that we might see as, I'm trying to struggle for the right word, just bad motives. Anyway, yes, please.
So this question is about the Hecox case, although it could be answered by any of you, I think. So the plaintiff in that case has withdrawn their lawsuit and asked for the case to be dismissed. And I'm curious what your thoughts are as far as how the court will see that and how they will likely decide on if the issue is now moot or not.
Yes, this is the Idaho case. So the plaintiff, who had been active in sports in Idaho, has said publicly she received so much harassment. She is no longer participating in sports at the University of Idaho and has asked that the case be dismissed as moot. The thing is, there are two cases pending. So even if the one case were dismissed as moot, the court could reach many of the critical issues in the context of the second case. And courts have the ability to say that something is, I don't teach con law, what's the phrase? Yes, capable of repetition and evading review. And that's certainly true here. So it may not matter. And I think the court has discretion in that case.
Since we've been talking about the interaction of the court and the political world, I was wondering, obviously, significant Supreme Court reform would require a constitutional amendment, which seems, far-fetched at this point, but I think it's probably good to think about it, because if the time ever arises, it's good to have some ideas. I was wondering if lawyers, judges, people who are solely in like the judicial realm, do they think about political changes or legislative changes to, or constitutional changes to the structure of the courts, to the Supreme Court? If so, like, what do they talk about? What are the ideas? And specifically, in Mexico, they amended the Constitution so that all judges are popularly elected to, even to the Supreme Court. I was wondering if the lawyers have been following that, if they have any thoughts on that.
A couple of just preliminary comments. I think you could actually experiment with this because a lot of states have elected justices and judges, so you can sort of see how it operates in those states where they have elected judges and justices. We just don't have that in the federal system. I don't mind it. I don't mind our federal system. President nominates, Senate confirms. I thought it was a little bit cleaner when the filibuster applied, and so confirming judges by a simple majority, I think will have some sort of lasting damage on the legitimacy of the judiciary. We'll see over the next couple of decades. As far as reform, I mean, the obvious practical problem is, typically one party is, there's a conservative majority right now. There's zero interest in Congress among conservatives to do any reforms, right? And so, you have the political side of any practical reforms that I don't know how you get past until there is sort of a less, maybe a more neutral court or more swing justices or something. I don't see it practically happening anytime soon. But I will say the alternative that I think is reasonable would be over a staggered period of time, expanding the number of justices on the court so that you don't have sort of each justice has a little demigod. And when they die, the whole country freaks out. Because if you spread that out, you have 13 or 15 justices. Each one's influence is reduced, and I'm a fan of that. But you'd have to stagger it so that it's not court packing. And proposals have circulated around that are bipartisan on that, but I don't think they're going to get any traction anytime soon.
And I'll make the observation that wouldn't require a constitutional amendment. Congress could just do that. But I agree they aren't likely to anytime soon. June?
Yeah, I have a lot to say about this. One of the, partly having lived in different states and seen different systems at the state level, one of the questions I think we should be asking is what role we want justices to play. And John Roberts has said publicly, he has defended the court, saying that the justices don't look at litigants who come before it and see whether there's an R or a D next to their names. So the court is not partisan in that sense. But he has defended the court as saying the justices each come with different ideological priors, and that's perfectly appropriate. I don't agree with that. And I don't agree with it because what you have, and this is very important to me, is a sense of do you have people whose loyalty to the institution is greater than their loyalty to themselves and to their particular sectarian sense of what the right answer is? And I see that in faculty politics. I will say the most divided faculties, not this one I'm on, are when you have professors who believe in a system of faculty governance, the cause, the right political views, the right reform views are more important than the well-being of the institution as it functions in a variety of ways. And what you have had is a decision, that goes back to disappointment with Justice Souter to only appoint, by Republicans, to only appoint ideologically pure justices whose votes can be predicted over time. And when you do that, when you appoint justices because of their ideological commitments, and I'm not saying all of the Republicans on the court were chosen for that reason, but certainly is a factor in the selection of most of them. When you have an ideological litmus test, you are in effect saying that the commitment to those ideals, whether legitimate or not, many of them are perfectly legitimate, are more important than, say, adherence to precedent or to what the court needs to do in a given moment. And that, I think, puts us in a terrible place. So now let me say, how does that relate to reform efforts? The problem with elections is they're incredibly corrupt. There are all these studies of Texas, which has had judicial elections for eons, and the role of campaign contributions in both selecting judges in the outcome of cases before the court, with people who contributed, law firms in particular, lots of money to judicial candidates, influencing the outcome of cases, is a major issue. When you have elected judges, it is a source of corruption. When I was in Kansas City and comparing Kansas and Missouri, there had been a system widely viewed as, Midwestern populist reform of having judicial commissions that had to approve the nominees. And that tended to eliminate both the most corrupt justices, but also the most ideologically driven justices. The bar tended to control that. Now, in the modern era, those kinds of movements tend to be criticized as elitist and also as insular. The people most popular with the bar are the people most likely to be appointed. But it tended to produce relatively more independent and less ideologically extreme state Supreme Courts. I can imagine that what will happen if you had Democratic control of the legislature, but not the ability to get through supermajority kinds of things, that you could imagine Congress limiting the jurisdiction of the court over certain kinds of cases. But obviously, constitutionally, the easy thing is court packing. And one reason why it's very hard to accept the current court as legitimate is not just the selection of ideologically extreme judges as a partisan strategy, but also the stacking of, Mitch McConnell's engineering of both saying he wasn't going to even hold hearings in Merrick Garland because it was too close to an election, but then rushing through Amy Coney Barrett's appointment in a smaller period of time. I mean, the hypocrisy makes it hard. And I want to emphasize, while both parties tend to pick justices who agree with them, Barack Obama, I can't remember if it was Obama or Clinton, is supposed to have said, it really doesn't matter who I appoint. Any Democrat I appoint is going to be here compared to where the conservatives are. And again, not all Republicans, but the conservative ideologues in the court are. And I think that's a terrible thing for the country because it means the basis for judicial decision-making now differs by party. And that, at least in the modern era, the post-New Deal era, is not true. The Warren Court was able to engineer a unanimous decision on Brown versus Board of Education, and Earl Warren was a Republican governor of California. This wasn't a partisan issue, and it wasn't so ideologically driven in the post-New Deal era.
Well, with that, we could get into a lot of discussion about ideology in the court, but we are out of time. So I particularly want to thank those students who were brave enough to come to the microphones, and I hope you've all found this very useful.